Okay, I think we will begin. We'll probably have some late stragglers come in, and of course, the meeting is being recorded and we'll be publishing online the majority of the webinar, minus a Q&A at the end. But hello, everyone, and welcome to the 10th webinar of the Grievance Redress and Accountability Mechanism of the Mechanism Partnership. I'm Peter Carlson, the Communications Officer at the Independent Redress Mechanism of the Green Climate Fund. Before we begin, I'd like to remind you about a few administrative matters. First, there is interpretation available for Spanish. So if you click on More at the bottom, you should find interpretation, and then you can toggle between English and Spanish. While we ask you to mute your microphones when you're not speaking, we invite you to share your video so that you can get to know the other members of the Grant Partnership. And as I just mentioned at the beginning, the webinar will be recorded and published online after the event. We'll remove the Q&As at the end that we'll have so that you can ask questions candidly to the panelists. I'd also like to take the opportunity to introduce our new head of the IRM, Sonia Durkum, who joined us just a month ago in August. She has nearly 2 decades of experience in accountability, recently heading the complaints mechanism for the European Investment Bank. And so we're happy to have her join us today. If you want to give a little wave, Sonia. And with that, let's begin today's webinar. It's hosted today by the OECD Centre for Responsible Business Conduct, and will focus on the recent update to the OECD Guidelines for Multinational Enterprises in Responsible Business Conduct. These guidelines, first established in 1976 and regularly updated, are recommendations jointly addressed by governments to multinational enterprises to enhance the business contributions to sustainable development and address adverse impacts associated with business activities on people, planet, and society. The guidelines are supported by unique implementation and non-judicial grievance mechanism, the National Contact Points for Responsible Business Conduct, or NCPs, established by governments to further the effectiveness of the guidelines. So let me now introduce our speakers and our panelists for today's webinar. We first have Nicolas Haché, who is the head of Access to Remedy at the OECD Centre for Responsible Business Conduct. He is notably responsible for supporting and coordinating the network of 51 national contact points for responsible business conduct, the domestic implementing bodies of the OECD Guidelines for Multinational Enterprises on Responsible Business Conduct. In that capacity, between 2021 and 2013, he led the negotiation process for the targeted updates of the implementation procedures of the guidelines. We also have Jennifer Zirk, the legal consultant for OHCHR's Accountability and Remedy Project. Dr. Jennifer Zirk is a freelance writer, researcher, and analyst specializing in business and human rights. She has advised on a number of significant law reform and policy initiatives in the business and human rights field, including most recently as lead legal consultant on the Accountability and Remedy Project of OHCHR. She is an associate fellow in the International Law Program at the Royal Institute of International Affairs, also known as Clapham House. Martin Skeltema is the founder of the Erasmus platform on sustainable business and human rights. He is partner at Pels Reichen since 2005, where he chairs the Business and Human Rights Practice Group. He's also been a member of the Dutch Supreme Court Bar since 1997, and he specializes in environmental, social, and corporate governance, or ESG issues, and especially business and human rights issues since 2007. He's a professor of private law at Erasmus University Rotterdam since 2011. And he is one of the founders of the Erasmus Platform on Sustainable Business and Human Rights, an interdisciplinary research group of the Rotterdam School of Management and the Erasmus School of Law. So moving on to today's agenda, first we'll have Nicolas present the latest updates with a particular focus, obviously, for this group on the relevance for access to remedy and NCPs. Next, Jennifer Zirk and Martins will join us for a panel discussion to provide further reactions and insights into the updates. pulling from their experience and expertise at the nexus of business and human rights. And at the very end, we'll open the floor to questions from GRAM members. So with that, I will pass the floor over to Nicola.
Thank you so much, Peter, and thanks everyone for joining. I'm really happy to be here, and really I'm thankful for the opportunity to present to you the targeted updates to the OECD guidelines that have kept us busy, I would say, for the better of the last 2 years, and in which access to remedy was really is one of the central projects, with the focus on the national contact points. I'm really excited to be able to present those to all the professionals in the room and have a good discussion. So really looking forward to that. So maybe before I really delve into the more technical aspects of the updates, let me, if you want to move to the next slide, give you the very quick overview of the guidelines. So as Peter, you said in the introduction, the guidelines, they're a set of voluntary recommendations that governments are making to businesses on how to behave responsibly on a very wide range of topics, in fact. So you have the 9 little icons on the slide that sort of represent all these areas, all these topics. I won't list them all, but you have human rights, you have labor rights, you have environment, corruption. So basically every kind of intersection that there can be between business and society is covered by the OECD guidelines. So it's a very, very comprehensive code of conduct that was adopted in 1976 for the first time, and then updated 6 times since the last time this year. And so, as I said, it's very comprehensive. It is particular in the sense also that governments can actually adhere to the standard. They're recommendations to businesses, but from governments. In that sense, the governments have to endorse the standard. So we have 51 governments that have endorsed the standard, 38 OECD members, and then 13 additional countries. And one of the things that make the guidelines unique, and that we'll discuss today, is that they do integrate an inbuilt implementation mechanism, the national contact points for responsible business conduct. And so my day job is really to support and coordinate the network of the 51 national contact points for responsible business conduct that are established domestically by the 51 countries that endorse the guidelines. So moving on to the next slide, one thing that I want to say is that obviously the OECD guidelines are not alone in the field of responsible business conduct, and there are other leading standards, the UN Guiding Principles for Business and Human Rights, the ILO Tripartite Declaration, which all have different scopes, but that are aligned on substance. So here, the OECD really working closely with the UN, the OHCHR, and the ILO, were really trying to make sure that we avoid fragmentation and that we avoid this sort of spaghetti bowl of norm effect that can be rather counterproductive. So there's really alignment between these two instruments in setting really a clear standard of conduct at international level for businesses. So now moving on to national contact points for responsible business conduct. So as I said, they're really one of the unique features of the guidelines. And as one of the governments that endorses or that adheres to the guidelines, there's a legal obligation to set up a functional national contact point. So that's a high-level obligation. There's no template or no blueprint for what national contact points should look like. They're all institutionally quite different. But they have 2 main responsibilities. One is to promote the guidelines, to disseminate them, to generate uptake and awareness of the guidelines. So that's a promotional responsibility. And then they have a responsibility, which we'll discuss a bit more today, which is to act as a non-judicial grievance mechanism for those cases where the guidelines haven't been followed. And then there's sort of an add-on to those two main responsibilities, which is to act as sort of a support office for governments that try to legislate or to regulate in the area of responsible business conduct. We see that more and more national action plans on business and human rights being adopted, increasingly also legislations on due diligence and other aspects of responsible business conduct, where we think that NCPs, with all the expertise that they've developed on responsible business conduct, really have something to contribute to those processes. So they can also act sort of as a resource in those efforts. So that's in a nutshell on national contact points. Let me just give you some more details on sort of the grievance mechanism. So if we can go to the next slides, just some quick facts about the grievance mechanism. So as grievance mechanisms, NCPs can receive complaints that are called specific instances in sort of the jargon of the guidelines. And they deal with these complaints as in a non-judicial way. That means that neither the participation of the company nor the outcomes can really be enforced. So in order for the case to move forward, NCPs really do depend on the good faith engagement of companies. And when that is the case, the NCPs will try to set up some dialogue and some discussions between the complaining party and the company to try to arrive at an agreeable solution. So it's a pretty soft process. It's really mediation and conciliation based, but it's also, so you could say that it's a limitation, but one of the real assets of the NCPs is that it's an incredibly open system. It's open in several ways. First of all, it's open by virtue of what I call sort of the in or from principle that concerns which companies can actually be taken in front of an NCP. So basically, NCPs can review cases that involve companies that operate in their country, wherever in the world they are from, or that are headquartered in their country and also operating anywhere else in the world. So you can really see there's an element of extraterritoriality in the jurisdiction, if you can call it that way, of NCPs that spans way beyond the 51 countries. And so you can see on the slide, NCPs have handled over 650 cases since they've acted as non-judicial grievance mechanisms, and the issues they've covered span 105 countries and territories, so well beyond the 51 countries. And on the slide you can see the percentage of cases per continent. And if you think that, you know, those 51 countries that have an NCP, they represent over 50% of global GDP, over 80% of world trade, over 70% of FDI stocks, well, you realize that, in fact, that group of countries really captures a lot of the world's economic activity, and that increases by as much the reach of NCPs. Just maybe one more thing, that the standing requirements to file a specific instance before an NCP are also pretty low. So any person with a person or organization with a legitimate interest can file a case. You don't need to be a direct victim or to prove that there's a law or that has been broken. You can just show that you have a legitimate interest and then file a case. So a lot of NGOs, a lot of unions file cases on behalf of an interest or on behalf of a different group, which makes the system quite open. Now, moving on to the next slide, just a word on the updates process. So as I said, we try to update the guidelines more or less every 10 years. The last version were dated back from 2011. And this update, the sixth one, was particularly timely and urgent, I would say, because I mean it's not a secret that, you know, the world's in a phase of many transitions. In fact, transition towards a low carbon economy, transition towards a digitalized economy, and all those transitions, all those risks do implicate businesses. And so it's important that they have a roadmap, that they have a code of conduct that's fully taking into account those challenges, and that they can follow. And for what concerns access to remedy and NCPs, there's also a lot of practice that had developed since 2011, not least, the Accountability and Remedy Project at OHCHR, but there's really a lot of practice out there that we could also take stock of and integrate in the guidelines. So that was really the spirit in which the updates have been done. They've also been done, that's something I want to underline too, really in close consultation with stakeholders from the business world, from the trade union world, from civil society, from academia. There have been really different consultations that have been consulted, so that we really were able to rely on a lot of input. And so the result was launched on the 8th of June of this year, after more or less 2 years of negotiation. So that's really for the broad intro to the topic. Now I'd really like to delve into what's new for access to remedy and for the grievance mechanism that NCPs operate, and maybe get a little more technical here, and because you're all experts in the field, and get into a good discussion. So I'll present to you the main updates that concern access to remedy and NCPs before passing to the discussants and then the Q&A. So if we can go to the next slide. So on the slide here, you can see the three sort of objectives that we set out to achieve when embarking upon the updates for what NCPs are concerned. And they were really about sort of a triple realignment, I guess, and that's because the grievance mechanism is really composed, as I said, of a network of 51 national bodies that all operate independently or autonomously, so to say. And we saw that there were a number of misalignments in those operations. Misalignments from the point of view of their effectiveness, misalignments from the point of view of how they interpreted their mandate and authority to act in the field of remedy, and also misalignment from a more procedural perspective. So how in practice was a complaint processed, etc. And all of those misalignments were creating really systemic issues, forum shopping, for example, contradictory decisions, sometimes not too many, but it could happen. Differences in sort of the standard of review that NCPs were applying, reputational risks as well. So when NCP sort of does not operate at the level it has to, then it reflects badly on all of them. So really, these were the challenges that we had identified and that we set out to tackle with the updates. So I'll really unpack how we went about updating the guidelines to tackle all those three challenges. But before I do that, maybe going to the next slide, let me say a word about sort of the normative framework around NCPs, which is actually quite complex. So if you just read the guidelines, you'll see almost nothing about NCPs, because everything that's about NCP is sort of in an appendix to the guidelines, which is composed of three texts. Sorry to be a little lawyerly and boring here, but I think it's important to understand. So those three texts have different sort of normative intensities, if I can say it like that. So at the top of those three texts, you have the OECD Council decision. So that's a binding instrument that's adopted by the OECD Council, which is the highest body of the organization representing all the member countries. And that document is pretty short, and it really does only contain sort of the basic obligation to set up an NCP and what responsibilities NCPs have, but with very little detail. The detail is left in an annex to the decision, which is called the procedures. And that annex is not binding. So that has a little bit more detail, and then most of the details, most of the examples on how to implement the procedures are in a much longer commentary, which comments both on the council decision and on the procedures. So it's a pretty weird, kind of setup, but that's how it's been. And so you'll notice that apart from the OECD Council decision, both the procedures and the commentary were non-binding. And so historically, it has meant that, in fact, a lot of the provisions were, in fact, left unapplied or ignored or simply not implemented. So we've tried in these updates to, even though we couldn't really touch the non-binding character of those documents, to still increase the level of expectation, if I can say it like that. So you'll see that in the procedures and the commentary, there are statements or provisions that contain the word will. So the NCP will. You have sentences that contain the word should, and you have sentences that contain the word may. And so the will statements are really those where there's a strong expectations that the NCP will comply. The shoulds are strong encouragements for the NCP to act in the way, and the may statements are those where there's a suggestion that NCP adopts a good practice. So that's one way to make those documents binding without making them binding. But definitely, if there's a will statement and the NCP is not complying, it's not good practice, and that can have consequences as we will see. So that's the three boring minutes about the sort of the normative framework around NCPs. And now let me try to unpack a little bit concretely what we have tried to do, starting with the question of effectiveness, the effectiveness of NCPs, what we call functional equivalence in, again, the guidelines jargon. So as I was saying in the beginning, all 51 NCPs look quite different. Governments really do have flexibility in how to set them up, and that created really inconsistencies in how effective those NCPs were. Some were really leaders and were doing really a good job. Others were barely functional and barely visible, and that was really creating issues. So there's a number of things that we sought to implement to make sure that we actually raised, not really the ceiling, but at least raised the floor for all NCPs and created some sort of benchmark below which, benchmark of effectiveness below which no NCP could fall. And that's the first action we took there was really to give a definition to what we call functional equivalence, which means that all NCPs, regardless of how they're set up institutionally, have to all be equivalently effective or equivalently functional. And we've benchmarked that against a set of criteria that are defined and explained in the commentary. So those criteria, just list them out for you. So NCPs, they have to be visible, they have to be accessible, they have to be transparent, accountable, impartial, equitable, predictable, and they also have to operate in ways that are compatible with the guidelines. So for those of you that are familiar with the UNGPs, you'll see some similarities with UNGP 31. It's not exactly the same language, but I think substantively we can say it's pretty well aligned, and definitely we drew a lot of inspiration from UNGP 31 in drafting those. So now you have a clear benchmark on what it means for an NCP to be effective, and no NCP is expected to fall below that line. So that's the benchmark on paper, but we know that in fact that won't mean much if the NCP does not have the human and financial resources that are needed to actually achieve that level of effectiveness. And that's a huge challenge, in fact. We know that 25% of all NCPs operate with less than one full-time equivalent staff, for example. Turnover is also a huge issue. Give or take, every year, 1/3 of all NCP personnel is renewed. So if you pick up the phone, you have 1 out of 3 chances that it's a rookie, in fact, picking up and not really an expert. So that's really been an issue over time. So now there's much stronger language on the need for governments, in fact, to invest more in this mechanism and provide NCPs with human and financial resources. Then a third type of action that we took was to insist much more on the need for NCPs to secure stakeholder confidence. And that's an extremely important aspect of being an NCP. So as I was saying earlier, NCPs are a pretty soft mechanism. So in fact, the confidence of their users is their main currency. If they don't have the confidence of businesses and of complainants that they will be an effective and honest broker, no one's going to submit cases, and no companies is going to accept to participate. So it's very important that NCPs build and maintain stakeholder confidence over time. And so here we've added provisions on how NCPs should set themselves up institutionally, insisting on inclusion of stakeholders. So really good practice out there means that NCPs will include representatives of civil society, business, unions in advisory bodies or even in decision-making bodies. And that's the case of more or less 3/4 of NCPs, but with this update, we're hoping that we're going to get to 100% soon, so that all NCPs can really secure stakeholder confidence and become more effective. So these are updates on paper on what NCPs should do, but how do we actually monitor that NCPs are on a path to progress and are implementing those updates? So here we've introduced, I would say, 2 monitoring mechanisms, 2 oversight mechanisms. First, there's a mechanism to address situations in which an NCP becomes non-functioning. So staff leaves, is not renewed, the NCP becomes inactive. Well, to date, when that happened, and it did happen in some countries, unfortunately, there was really no mechanism that the OECD could implement to actually tell the government that it needed to restore its NCP. Now there is one. I will spare you the details, but it's the investment committee of the OECD that oversees the implementation of the guidelines that can take action and give recommendations to the government in question. So that's fully new. And then something that's not fully new, but that will become much improved, is the system of peer reviews. So the peer reviews, they're really the standard method in the OECD to monitor compliance of governments with OECD standards. So we already do have peer reviews of national contact points, but they're voluntary. So peer review NCPs can request to be reviewed by some of their peers to have a report and recommendations. And peer reviews are quite effective in ratcheting up the effectiveness of NCPs. So in the future, those peer reviews will become mandatory. And so we expect here to really establish a cycle whereby NCPs will be reviewed every so many years, so as to really be evaluated and get recommendations on how to maintain a good level of effectiveness. So those are two mechanisms that seek to add a little bit of teeth to sort of the effectiveness criteria and recommendations that I laid out a bit earlier. So that's for effectiveness. Then let me move on to what I was saying about the interpretation of the NCP mandate and authority. So if we can go to the next slide. So as I was saying, NCPs have two main responsibilities: to promote the guidelines and act as non-judicial grievance mechanisms. But those are defined at a pretty high level. The procedures were non-binding until now. So that means that there was actually a lot of diversity in how that mandate was interpreted and how NCPs viewed their own authority to act in those areas, and in particular in the field of remedy. Having to deal with a complaint and with large companies, etc., that can be like a bit of a daunting task, can be quite intimidating. And so you had some NCPs that were not comfortable with sort of acting as a strong accountability mechanism for businesses. Others were more comfortable with that. But so you see a lot of this, you saw a lot of disparities in how that mandate was being interpreted. And so we sought to clarify that mandate in the procedures. So I won't give you everything, but just some examples of how we've clarified how NCPs should view themselves as grievance mechanisms. So one important addition was that NCPs are expected to give recommendations to companies, in particular if the dialogue that they set up does not result in an agreed solution. Then NCPs should not just leave it at that. They should tell the company what it is they should do to bring themselves into line with the guidelines. So that's good practice, so that it does not all depend on an agreement which is a long shot. Every time less than 40% of cases that go to mediation reach agreement. So it's important that in the 60% of cases where there's no agreement, there's some outcome that can actually maybe lead to remedy in the future. And so this is something where NCPs are already quite active in terms of good practice. 85% of cases usually contain some recommendations at the end, and those recommendations are published in a statement on the case, etc. So that's quite important. Then a second good practice that we sought to generalize was to make sure that NCPs follow up on cases, that when there's an agreement, they follow up to see if the agreement is implemented. When they make recommendations, they follow up to see if the recommendation is implemented, and publish a follow-up statement to make it transparent whether the company has in fact become more responsible. So that's also a very important and a very impactful, I think, change that we made. And then before moving on, sort of a third sort of clarification that we made. As I said earlier, NCPs cannot force a company to participate in the process when there's a complaint. But still, in the guidelines, part of being responsible means also that, when there's a complaint against you, you're supposed to engage in good faith with the complaint and see if there's something that you could do to address the complaint. And so to add a bit of a consequence to that, there's now a paragraph in the guidelines that encourage NCPs to report companies that refuse to engage in good faith with specific instances. So, for example, an NCP could say, well, that company, there was a complaint against them, they refused to come to the table. Well, I'll go to my expert credit agency and tell them, look, if that company applies for expert credits with you, then perhaps you should take that into account, the fact that they haven't wanted to engage with me. Same with economic diplomacy, etc. So this is a practice which is still marginal with NCPs, but that has proven quite effective in the countries where it's being implemented, in Germany and Canada, and so we'd hope that it will become more generalized in the future. So I'll leave out the last two bullets because they're not directly about access to remedy, but this is how we wanted to basically make sure that NCPs felt more authoritative and more assertive in acting as a non-judicial grievance mechanism. Then I'll finish with some words about sort of the procedures. So how procedurally do NCPs handle complaints? Here again, you had a lot of divergent practice, which led to quite a bit of forum shopping, where complainants tended to go to the NCPs where that had a bit of a lower procedural threshold for a case to progress, etc. So we really wanted to here again harmonize the procedure to make sure that, you know, when you go to an NCP, you follow to whichever NCP you go to, it's more or less the same process that's being followed. So you can see on the slide, there's a number of things that we've added. First, sort of the hard requirement for NCPs to publish case handling procedures. So that seems like a no-brainer, but it's still quite important. 90% of NCPs already have that, so it's pretty well followed already, and it really is important for predictability, which is one of the effectiveness criteria. There's also a lot of detail that was added on how NCPs should coordinate with each other in case of multi-country specific instances, which are quite frequent. 25% of cases, more or less, involve more than one NCP. For example, because several companies from different countries are involved, because it's one company from one country causing issues in another country, etc. So in those cases, there was often a little bit of confusion as to which NCP took the lead, which NCP published a statement at the end. So now there's a much clearer process for that. Then third bullet here, we've also clarified what we call the initial assessment criteria for NCP. So the initial assessment criteria, it's a little bit the admissibility phase for the specific instances. So NCPs are supposed to look if there's an appearance of merit to the case before taking it forward, if I can summarize a little bit. But in the past, appearance of merit meant very different things for NCPs, and some actually applied a pretty high threshold to that, requiring a lot of evidence, a lot of argument before they would even examine the case. So now we've made sure that there was a low admissibility threshold, and all that needed to be shown by the complainant was that the issue they were alleging is covered by the guidelines, and that they at least had some documentation and some credible information to substantiate those issues. So it's supposed to be a low threshold. I see I'm out of time already, so I won't speak to all the rest. But one thing that I want to flag is this fully new language as well that we have on addressing risks of reprisals. We get increasingly often reports from civil society that people that file a case with NCPs are subject to pressures, reprisals at different degrees. So now there's really clear language in the procedures that there should be zero tolerance for that, and that NCPs can take measures to protect any party that would be subject to that, for example, by not disclosing their identity to the other party, etc. I mean, so this is language in principle in the procedures. But obviously, there's a lot of training that is needed to make sure that this becomes a reality, and so NCPs will undergo that training to make sure that they can react appropriately when those situations happen. So just going to my last slide, just a few words of conclusion, and also the latest group picture of the 51 NCPs, so you can put faces to the names. But so, I mean, I've just given you a very broad overview of the updates, but I mean, in my opinion, they're still quite substantial. We've really covered a lot of ground and been able to integrate a lot of good practice in the new procedures. But a lot of those updates are still shoulds or mays. You remember what I was saying in the beginning. So they're still suggested or recommended. So it will be up to NCPs to really put those into practice. And that will require resources. NCPs are going to have to become better resourced, have more expertise, become more senior, etc., in order for the mechanism to really raise a level and become fully effective. So ultimately, what it will take is for governments to invest in the mechanism and show that they are committed to this standard. So I'll leave you with that, and thank you for your attention. Looking forward to the discussion.
Thank you, Nicolas, for this very in-depth presentation. I think for me, just even from the very beginning, talking about how there's 51 adherents to the guidelines, but that doesn't mean that NCPs only cover 51 countries, and the range of kind of in and out that you mentioned and the geographic scope that these guidelines cover, I think is quite impressive. And obviously this network that you also handle is something that I think, especially us at the IRM, is with the amount of accredited entities that we deal with and the kind of network, I guess you could look at it similarly in some sense, in managing and having a certain level of effectiveness and criteria in place is also, I think, quite interesting. But now I think we wanted to offer our two panelists to come in, and we have a couple of guiding questions, although I think I'll let them kind of come in based off of their own experience and provide some remarks that they see with the updates. These questions here I'm just going to keep on the screen, and I think we can also keep them up for the Q&A at the end. But maybe I'll first pass the floor over to Jennifer for you to come in and provide some comments.
Thank you so much, Peter. And so thanks so much for the invitation to come along and speak today about this really exciting and important project. It's always such a pleasure to engage with your network. Your webinars are always so well done and interesting. So thank you so much. Nicolas has given us so much to talk about. I will kick off with the first question, if that's okay, about the most significant updates. I'm speaking from my perspective as having worked for 10 years or so on the Accountability and Remedy project over at the OHCHR. I'd say that all of these updates are generally and very positive for affected people, and they do reflect a substantial amount of learning that's gone on in the decades since the endorsement of the UN Guiding Principles, which we've been striving to capture as part of the OHCHR's Accountability and Remedy project. I'm just going to single out two things that jumped out at me as particularly important from the perspective of people who might want to use these mechanisms. The first is the increased emphasis in the guidance on the importance of stakeholder engagement on the processes that govern the handling of specific instance procedures. And the second is the raised awareness, as Nicolas was just saying just now, and the clearer language about the risks that people raising complaints and their representatives as well might be subject to intimidation and retaliation. So dealing with those in that order, and beginning with stakeholder engagement, the strengthened messaging in the new implementation provisions about the need for meaningful consultation with stakeholders, along with concrete suggestions about how stakeholder confidence might be enhanced, is just so important. We concluded from our work that the extent to which mechanisms engage proactively and constructively with stakeholders, both on the design of mechanisms and also in the resolution of specific cases, was the single most important factor in a mechanism's overall effectiveness. And I mean, it kind of stands to reason that people are far more likely to trust and make use of processes that they've kind of had a hand in helping to shape than will be the case when processes are just, and also outcomes are just imposed on people. And also the seriousness with which operators take this has a significant bearing on how well the mechanism will meet different effectiveness criteria. And also, and obviously, we welcome the the decision to try and sort of create more consistency and benchmark against specific criteria. But meaningful stakeholder consultation isn't easy, especially for mechanisms like like NCPs that cover such a wide range of sectors and issues, and which may be asked to resolve issues involving the possibility of human rights related harms happening in other jurisdictions. So how do you engage meaningfully with stakeholders when issues are so diverse and stakeholders can be difficult to identify in advance? In our guidance, we recognise the vital role played by trusted local partners, civil society organisations, unions, environmental organisations, those kinds of experts that can act as trusted proxies for wider groups. I think the recommendation in the updated procedural guidance to include representatives of stakeholders in advisory and oversight bodies is a really good one. And again, it's an innovation that we've reflected on in our own work, and it appears in our own guidance, and it's something that we'd like to see widely adopted by many other many kinds of grievance mechanisms working in this space. Turning now to retaliation and reprisals, I'll just say just a few brief words about those. I mean, I think the OECD's new recommendations and clearer language about risks of reprisals are also very, very significant and important. Fear of reprisals is such a significant barrier to people coming forward and using these mechanisms. We made in our own guidance a number of points about keeping people safe, which I think are important to bear in mind here too. And one point is that offering confidentiality is very, very important to people, but frequently not enough. And this is something that the OECD guidance does seem to recognise. In addition to guarantees of confidentiality, there may need to be additional measures to guard against inadvertent disclosures of the identity of people who may be at risk. Another important thing to remember is that, and this is something that really struck us from our own research, is that retaliations can take unexpected forms. They can be very subtle and rooted in cultural norms that may not be immediately apparent to practitioners working in the grievance mechanism. So people not sharing that particular cultural background and without that lived experience might not spot the significance of certain behaviours and implications of what is being done, and also the interplay that can exist between different risk factors. I'll stop my comments there, but I just wanted to finally say that I think the clearer expectations around recommendations and follow-up, and also more predictable processes, reporting of non-engagement. These are all things that will be of great interest to prospective users of the mechanism. They're incredibly important for strengthening the mechanism and securing greater credibility for all of those processes. So congratulations on all of those.
Thank you, Jennifer, for your insights, especially coming from the perspective of OHCHR, which I know has done some a lot of. There's a recent study which I think if you want to share in the chat with a lot of recommendations around grievance redress procedures, I think the community can obviously benefit a lot from that, and I can even share it by email as well. But let's move now over to Martin. I know coming from the Netherlands, you also have some experience, especially with the NCP in the Netherlands in that perspective. But yeah, I'll hand the floor over to you.
Yeah, thank you, Peter. And as Jennifer, I'm very honored to be in this panel, and well, I may echo her words in terms of the very good organization and format of these webinars, which I always really enjoy as well. I may also echo her compliments regarding the updates of the OECD guidelines and especially also regarding the NCP procedures. I think there have been implemented a lot of very helpful and I think also good improvements. For example, also regarding non-functional NCPs, in terms of the accessibility of the NCPs and trying to align for example, also the rules for engagement for the NCP. So I think there have been made a lot of very good improvements. And well, Jennifer already provided many very insightful observations, and then it's always a challenge to add some more relevant ones, but I will try. From my perspective, there are three kind of important things which are partially addressed, I think, in the update, but well, there are still some relevant things remaining, I think. Well, I have kind of basically three observations. The first one regards parallel proceedings, but also the kind of collaboration with other mechanisms. And the second observation, well, it's connected with, well, what happens after the final statement of the NCP. And the third one is connected with the upcoming European legislation, the Corporate Sustainability Due Diligence Directive, which, well, will, at least to a certain extent, oblige larger companies to conduct due diligence, human rights and environmental due diligence in their supply chains. And how, well, that's kind of connected with grievances and also the NCPs. In terms of the first observation regarding parallel proceedings and the use of other mechanisms, I think it's very good that the updated guidelines now also include some language on the question how, well, NCPs could collaborate, and also, well, in terms of lead NCPs and following NCPs when, well, a complaint is filed with multiple NCPs. I think that's very helpful and also very relevant, I think, because that often happens, and I think it is very good if that kind of language is in. So that, I think, is a big compliment for the improvements made. Though of course there are some kind of desires which still may well be a thing for a next, or at least to think about, because the language on parallel proceedings is now mainly kind of related to, well, what happens if court proceedings in national courts are also pending, and how do we kind of prevent contempt of court, but not so much, and so only in terms of, well, what do we do when these proceedings kind of, well, are pending next to each other. And there's also, of course, language on collaboration between NCPs, but not so much language on the question about what happens if, and maybe also how do we kind of establish a kind of relevant collaboration with other non-judicial mechanisms, for example. And of course, the Graham Partnership is kind of built around all these kind of other non-judicial remedies. So from the Graham perspective, well, that probably is a kind of relevant thing as well. And I think, well, it would be good if the NCPs, and also maybe in collaboration with the Working Party or the Investment Committee, could also kind of think of some guidance regarding collaboration with, for example, local mechanisms. Because what we often see, and I've also kind of had that experience as a chair of the dispute resolution mechanism of the Garmin agreement in the Netherlands, that it is very hard for stakeholders unless they have kind of assistance from international NGOs to kind of access those more international mechanisms. And though, of course, the NCPs do a lot of work to kind of enhance accessibility, that still, I think, often requires, well, the help of NGOs. And of course, well, we all know that NGOs are doing their best, but cannot find all issues and cannot support all stakeholders who may need that. So what may be a thing to further explore is how NCPs can also be connected or maybe used as a kind of follow-up mechanism next to, for example, local mechanisms. And, well, the advantage of that may be that, for example, the local mechanisms could be well informed and maybe also know how the kind of follow-up, for example, with the NCP may work. So they may also guide the parties in the local mechanisms and may assist them in terms of what may happen with NCPs. It may help in terms of informing NCPs, or to the extent possible, about what happened. And what may also be very important, I think, as a function of those more local mechanisms and connecting with them, is that indeed, as Jennifer also emphasized, the prevention of reprisal is very important. And I think, well, that's also well recognized and acknowledged in the improved guidance. But indeed, the forms of reprisal may be not so obvious to us, and maybe, well, the claimants themselves may be well protected because the NCP kind of sees to that, but it may also kind of be directed towards, for example, family members and others, which are not very well known by the NCP. And maybe these local mechanisms who are kind of more culturally informed may kind of, well, have a kind of better sense of what may happen in terms of reprisal. So that may also help in terms of preventing that kind of reprisal. So well, my recommendation there would be whether it would be possible to kind of explore a little bit more guidance in terms or best practices with the NCPs, how this collaboration with especially local grievance mechanisms may be better shaped. Then on my second point, what happens after the final statement? Well, there, of course, I think the effectiveness of the NCPs, but of course that's not a thing of the NCP itself, and maybe, well, more a thing for the investment committee or the working party, but what governments can do in terms of following up the NCP statements. And for example, well, what do governments do in terms of public procurement? Or what do governments do in terms of trade missions? Or what do governments do in terms of export credit insurance? And that, well, the NCP final statements, especially if the NCPs have kind of observed non-compliance with the OECD guidelines, well, may kind of have that kind of consequences. And so I think in terms of promotion of the OECD guidelines, it may also be important, I think, to further explore with the government, well, how that may work. And there, I think, and then, well, that's a kind of, well, thing which I, well, would have seen, but did not kind of, well, wasn't kind of part of the improvement. But that at this point, NCPs may explain whether they feel companies have kind of observed the guidelines. So in the final statements, they may do that. So, and as you very eloquently explained, that means that it is guidance, but not obligatory. And what we see is that many NCPs do not do that. And I think the kind of statement on observance of the OECD guidelines is quite important, I think, for the follow-up actions by governments. Because if it's unclear whether the OECD guidelines have been kind of complied with, well, then it may be harder for governments to say, okay, well, from the final statement, it kind of is quite clear that you did not observe because it's not in there. But if the NCPs, and the Dutch NCP usually does that, indeed observes non-compliance, it's easier. So I think that would be kind of recommendation there. And also, I think for the countries especially in Europe, which are now implementing or already have due diligence legislation, this may also be very important for the public supervisors, because the public supervisors, and I think, for example, NCP final statements may be very relevant for public supervisors in terms of, well, kind of starting investigations, for example, on non-compliance with the due diligence laws. Because if you have not complied with the OECD guidelines, well, that may be a very clear signal that there's also something wrong with the law. So compliance with the law. So I think, well, that kind of, well, final kind of statement, including observing, well, whether the OECD guidelines have been observed, may be very relevant for the following up. And I think may also make the NCP statements more effective. And then on the last thing, how it relates to the CSDDD, so the European envisaged, is not yet adopted, legislation on human rights and environmental due diligence. Well, I think there it's a missed chance in terms of European legislation that, well, the CSDDD includes no language at all on NCPs. It includes an Article 9, which requires companies to kind of build their own grievance mechanism, or participate in others, but no language on NCPs. And I think that is kind of missed chance, because the NCPs in the European countries are quite active, functional, and so kind of missed chance to kind of not use them. And I think it could also have been clearer, for example, in connection with liability or in connection with public supervision. Well, what the kind of consequences of NCP final statements, especially those kind of observing non-compliance, would have in terms of the legislation. And I think, for example, what I would have been kind of, I think, logical would be that if non-compliance is observed by an NCP, that would be a kind of, at least for a signal, or a clear signal maybe even, of non-compliance with the law. And but that's kind of completely not addressed, and I think, that's also a pity. Peter, I will leave it there. Thank you very much.
Thank you, Martin. I think that's been really helpful for the discussion, especially bringing up the points around collaboration with other mechanisms, the effectiveness of the NCPs, and then also thankfully tying it in also to the kind of EU legislation and the other directives that are going on that coincide a bit with the OECD updated guidelines. Before we move into the public Q&A, Nicola, did you want to respond to what Jennifer and Martin had brought up?
Yes, no, thank you for these very insightful comments, and I think you really exactly zeroed in on the things that were probably among the most vividly discussed and the most controversial, I think, in the updates process. So I'm really not surprised. So it's very sagacious of you, for sure. I really liked that Jennifer, you recognized that stakeholder engagement and stakeholder inclusion was really central to the effectiveness of NCPs. I guess meaningful stakeholder engagement is a little bit part of the DNA of responsible business conduct in the first place. So it's only logical that NCPs operate by the same sort of standard. And so, yeah, we've really tried to push for this. But when you look at the practice, it's still pretty difficult, in fact, to make happen. Like, first of all, very often NCPs don't necessarily have control of their own setup, so it requires sort of a decision from the top to change the structure, and that can be a pretty heavy lift, in fact, to achieve. And then second, really on the practical matter, I mean, RBC is such a broad agenda that you potentially have dozens or hundreds of potentially interested stakeholder representatives. So who do you select? If you want to be inclusive, how do you keep your NCP or your advisory body manageable? How often does it meet? Is there not a risk that it will completely cannibalize all the time of the NCP? So it's really a fascinating kind of debate here. What's the right model for every different country, etc. But I mean, at least in principle, we're really happy that the principle of stakeholder confidence and even inclusion has been recognized and is being encouraged. So we expect to see a lot of movement and debates at national level on how to get this right for each individual NCP. Then there was what you said about retaliation. Yeah, extremely sensitive topic. I think everyone agrees that it's absolutely essential for the proceedings to be safe. But again, in practice, and this is why also I was saying that NCPs will just not need some broad guiding principles that reprisals should not be tolerated, but also really in-depth training on how to recognize those situations. You were talking about, cultural aspects to reprisals, and notably the fact that usually we tend to see reprisals as the company on the one side doing reprisals against the complainants, but in fact, very often it's not like that. Sometimes even within the community where the complainants are from, you have people that are in favor of the company and that might sort of take reprisals against the complainant outside the knowledge of the company. So it's really a multi-faceted phenomenon, and there are a lot of different ways to actually take action, not just keep the identity of the complainant confidential or anonymous, but also maybe use proxy, maybe use proxy organizations, or create some dialogue among the community where the people that are making the complaint are from, etc. So yeah, really, again, here we've recognized the principle, but we've just opened up an entirely new line of work for NCPs to consider, I think. And so we're currently working on some sort of guidance for NCPs on how to do that, and organizing some trainings that will happen in the next few months or years. So it's really top of the agenda for us. So thanks for recognizing that. Then just also quickly responding to Martijn's point, also really three excellent points on parallel proceedings. It's true, very often the collaboration between NCPs and other bodies, or between other bodies, not necessarily NCPs, that can be a little messy because they all have their own focus, their own jurisdiction, their own methods, etc. So if you have these very different processes running in parallel, well, who takes the lead, what do you do to keep decisions consistent, etc. So this is something that we recognize we need to also do some work about. And I mean, in the commentary to the guidelines, when we talk about parallel proceedings, there's an encouragement for NCPs to reach out to any other mechanism that that might be running parallel proceedings. But the details of what should happen, haven't been really substantiated, because there's just a wealth of different situations. But one thing that I can say is that just before we started doing the updates, NCPs were actually looking at that particular issue of parallel proceedings, and we're starting to work on the guide for NCPs on parallel proceedings. So if you're familiar with our webpage, you see that there's a number of guides for NCPs on a whole number of procedural aspects of their mandate. Well, soon there will be one on parallel proceedings. We had just begun that before the updates, had pressed pause just to see what the updates were going to say about that, and we're going to resume on this very soon. So it's also a very important, I think, mechanism, and also one that can really enhance accessibility and positive outcomes for complainants. So that's on parallel proceedings. On what you were saying about determinations, so it's probably the most contentious issue in the NCP community, or between business unions and CSOs, whether NCPs should actually make pronouncements or determinations about whether or not a company has complied with the guidelines. Some NCPs do it, others really think they shouldn't be doing it. And I think that question is really at the center of, sort of the two different approaches that an NCP could take to their role as a grievance mechanism. Should they be an accountability and a compliance mechanism, or should they be sort of an implementation, learning, dialogue platform? And to where, like, if they start doing determinations, might that tilt them a bit too much in one direction and not in the other? So that's really the debate. So this is, I mean, the jury's still out on whether it's best for an NCP to be making determinations or not. It's not something that we have wanted to pass judgment on in the updates. But still now, just for the sake of predictability, it is recognized in the procedures that NCPs may, if they think it can help a solution to the issues, they may make a determination, and they should ideally write that in their case handling procedures. So for predictability, parties can know if the NCP in front of which they are will make a determination. But I think there's no hard and fast answer on whether NCP should or should not do it, because there's a whole bunch of repercussions, some of which, and then to your third point, might implicate binding legislations. If an NCP makes a determination, then suddenly it can actually become almost hard law if a judge takes that into account to assess whether a company has complied with their legal obligation to do due diligence, for example. So it's really a difficult question. But then on the CSDDD, like you were saying, you're right that the Commission proposal and the Council position on the CSDDD don't contain language on NCPs, but the position of the European Parliament does, in fact, contain quite some language on NCPs, and notably to recognize, first of all, their promotional role in relation, for example, to supporting measures, but also their role as a grievance mechanism. And in particular, a recognition by the supervisory authorities, which will verify compliance with the law of the mandate of NCPs. And I think that's quite important because you don't want these two bodies to sort of enter into competition or to disregard each other's procedural rules. For example, confidentiality of information is quite important before NCPs. So in case a supervisory authority learns that there's an interesting case that's going on before the NCP in their country, could they request to see all the documents, all the memoirs, etc., that have been shared by the parties? Well, that would be a complete disincentive for companies to engage with NCPs, for example. So there's really some fine-tuning that needs to be done there, and we're maybe seeing that in the Parliament's draft, and for the moment they're in the trilogue phase. So hopefully this is something that will be considered in the outset. But that's really not something that I can predict at the moment. So I'll leave it there. Thanks so much for the comments, Jennifer and Martin. Super interesting, and then happy to answer any question from the floor if there are any.